All right. Hello, everybody, and welcome back to Raw Law Unfiltered. Long time no see, guys. Like, what, 10 minutes, 6 minutes ago? For those of you just joining us from the Jason Goodman stream, we are going to read one of the best filings, the most beautiful filings I have ever seen in my entire ever fucking living life as an attorney. It is short, it is sweet, it is direct, it is to the point. It outlines everything that is wrong. It does not go into immense detail. It is just like boom, boom, boom. Get in, get out. This is how lawyer work is supposed to be done. Leave it to fucking Ben Chu and Camille Vasquez to show us, you know what, you guys? This is how you fucking lawyer. This is how you do this kind of stuff. This is how you make a filing. This is how you make a proper legal document to address all nonsense, 150 plus pages of bullshit. This is how you respond. And I am in it to win it. It is absolute fucking chef's kiss. So without further ado, let's get into it, shall we? My God. My God. Okay, this is so. Remember, we have two parallel appeals. Just to remind those of you who may have forgotten, we have two parallel appeals. We have Johnny's appeal and we have Amber's appeal. This has nothing to do with Johnny's appeal. We're dealing with Amber's appeal. Okay, this is Amber's appeal against Johnny. This is Amber appealing her $10.35 million judgment against her. Okay, in that appeal, so far, we have had 3 briefs filed. We have had Amber's opening brief and 2 Amici briefs. Okay? All of those we have read on my channel. If you haven't seen them, go check them out. They're in the playlist of Johnny and Amber's appeal. Now, within those 3 briefs, only one of them is mandatory. The other 2 are optional, and both had to file leave of court, meaning request the court to allow them to file them. They can't just like amici briefs come out of nowhere and be like, all right, we're injecting ourselves into our appeal, into this appeal because we have a vested interest. That's not how it works. The Court of Appeals still has to say, I give you permission, go ahead. We will read them, right? But you don't ask first and then file. You ask and file at the same time, and then the court may or may not ever read them, right? Okay. So now that we're all caught up, this is Amber's appeal. This is the amici briefs that were filed on behalf of Amber by those women's organizations, the 40 names or the 30 names or whatever it was that we had over there. I don't remember the exact number. Amber Laura Heard, see, she's the appellant because this is her appeal. Johnny Depp is the appellee. This is the case number. And this is the title. Appellees, meaning Johnny Depp's, Appellees omnibus opposition to amici's motions for leave to file briefs amicus curiae. We got to start explaining what the fuck that means, because this is already confusing to some of you who don't legal speak, which I imagine is the majority of you. So allow me to please elaborate. Appellees, who is it? It's Johnny Depp. He's the one who's filing this motion. So appellees. Omnibus is a fancy legal term for it means encompassing all. Greek root omni is like the Omni Hotel. If you all are familiar, it's the same. It's the same word. Omni means encompassing all. Omnibus, opposition, means we are opposing whatever you did. We are not agreeing with it. To amici's motions. So they're opposing the motions filed by the amici, their leave to file their briefs amicus curiae. So we're opposing your request to have the court read your shit, basically. And this is our global opposition. This one motion is going to cover both of your filings, and you will see why in a moment. Appellee John C. Depp II, Mr. Depp, by and through his undersigned counsel, respectfully submits his omnibus opposition for the motion for leave to file brief of amici curiae Sanctuary for Families, the Virginia National Organization for Women, the DC Coalition Against Domestic Violence, Equality Now. They have to list all of them. I'm not going to go through them, but you see that over here. This is going to be called the Simpson motion and the Simpson amici, as well as the motion for leave to file amicus brief filed for the amici by Fletcher, Heald, and Hildreth. We're going to call that the Fletcher motion and the Fletcher amici, and collectively with the Simpson amici, this is just globally going to be called the amici. Okay? Stating as follows. And why is there a little asterisk here? Why is it this omnibus? Remember, I told you the omnibus, we're going to cover all ground at once, because Ben Chu takes no fucking prisoners. Ben Chu is like, look, you're going to start some shit. I'm going to take an axe to your fucking little machete, and I'm going to axe your shit, because that's how Ben Chu does. Ben Chu don't take no fucks. I'm serious. This is how lawyer work is done. This is like class A fucking work. This is not like, well, let's talk about all of the potential things that could potentially. No, Ben is like, let's get to the point. The point is, you filed this. I'm not going to waste your court's time. Read this motion. It is a few pages. I'm going to address everything you need to know. Here's why. Boom, boom. Wham, bam. Thank you, ma'am. Literally, it is like a lawyer's fucking dream. It's like I'm going to be reading this shit to people one day. Like, look, this is how you write a fucking response to a brief. This is how you do it. This is a class A example. This is what you're supposed to do. This is it. I'm telling you. And look. You may say like, oh, well, Larry, obviously you're going to say that about, you're like on Johnny's side. You've been there since the beginning. No, that has nothing to do with anything. It is the simple fact that this is so good. This is like, I swear I'm salivating right now. This is how good it is. Glow T says, you're the best. Thank you so much, Glow T. No, you're the best, Glow T. You're the best. Thank you. It's like so good. So omnibus opposition. So what does omnibus mean? To avoid, this is what Ben is literally telling the court. Look, to avoid burdening the court with duplicative briefings like you fucking did, Amber and her team. You filed like 2 amici briefs and blah, blah, blah and bullshit. I'm not going to do that. To avoid burdening the court with duplicative briefings, and because the issues overlap, Mr. Depp is going to address both motions in this one opposition to save you the time, to save you the energy, to save you having to read double speak twice. Doesn't make any sense. This is how lawyer work is done. Ballard Spar, take fucking note, okay? You could learn a thing or two. Same goes for Ben Rottenborn and all these other firms that have joined in on the amici brief filing charade, because that's literally what it feels like at this point. Now, the first words out of the gate, we're just in the introduction now. And Ben is like, again, he pulls no fucking punches. He's like, this is a kitchen sink appeal. Like, mic drop, bro. Fucking mic drop. Out of the gate. I'm telling you, he just gets to the point. This is a kitchen sink appeal. Period. The end. Signed, Ben Chu, submitted. Like, I'm dreaming of a day where he fucking did something like this. This is a kitchen sink appeal, with appellant purporting to assert no fewer than 16 assignments of error. We're literally throwing everything on the wall to see what sticks. This is how it backfires when Class A lawyers take your shit and they literally expose it to the world. You don't have like 1 or 2 issues. You don't have 1 or 2 assignments of error. You have 16, and you have 2 amici briefs that. Okay, I'm getting ahead of myself. Let's read on. Just follow along. Appellant Amber Laura Heard, Ms. Heard, who is represented by 2 large and well-regarded law firms, is seeking to relitigate virtually every major ruling made by 2 distinguished and highly respected chief judges of the Fairfax County Circuit Court, the Honorable Bruce D. White, who's since retired, and the Honorable Penny Escarati, the one who has been the judge on this trial throughout. Over the course of a 3-year litigation and 6-week jury trial, that's what they're trying to do. In addition to the oversized brief of 55 pages. Because remember, Amber asked for extra time, extra pages, extra. Give me more. Give me more. Okay, too much Britney Spears for you? All right, I understand. Sorry, I'm like giddy right now. 55 pages that Ms. Heard has filed in support of her appeal. The amici seek to present a collective 93 pages of additional argument in support of Ms. Heard's positions. If these motions are granted, Mr. Depp would be required to respond to a grand fucking total of 148 pages with his own brief, which presently is set at 55 pages. So, like, the alternative would be judges will give us an opportunity to expand, and file our brief, triple the size. And no judges do not like to read extra, excess, unnecessary stuff. When given the opportunity to axe things, they will axe them unless they are so highly relevant and would be prejudicial to exclude. This is why remember I made this point 2 weeks ago when I said these amici briefs are pure garbage and they're a pure PR move that has absolutely nothing to do with the fucking case. This is it. This has been telling it to the court. This has nothing to do with the fucking case, and it's all garbage. It's a kitchen sink appeal. That's what it is. That's exactly what I've been talking about. This is now Ben Chu finally saying, he's like, all right, let me plop this bad boy on the fucking table and let me show you what's up. You ready? That's what's happening. This is it. This is what we're reading. This is only the tip of the iceberg. This is only the tip. Just the tip. Love your excitement, says Tammy Hoshiyama. Thank you so much. I'm just excited about this stuff. This is like amazing. Okay. Though there are doubtless cases in which briefing by amici curiae might assist the court in resolving the issues before it, this is not one of them. Mr. Depp respectfully submits that the filing of such extensive additional briefing by amici curiae here is neither necessary nor appropriate and should not be allowed. As a threshold matter, the court should deny their motions because the amici failed. So so we got to reason number one. Reason number one, it's too long and unnecessary. So 93 pages. 93 extra pages of garbage. You don't need to read it. It's a waste of your time. Court. Okay? That's argument number one. Number two, in order to resolve the issues before you, you do not even need these amici briefs in the first place. That's argument number two. Argument number three, as a threshold matter, the court should deny the motions because they failed to comply with the applicable rules. What did he just say? What did he just say? Let me read that again. The court should deny the motions by the amici curiae because the amici failed to comply with the applicable rules. They didn't follow the rules of the court? Uh-oh. Oh, now that's a big bombshell. Now that is a big bombshell. Let's see. Among other things, neglecting to properly assign error, which is one of the requirements. If you this basically what the amici curiae lawyers did not do, according to Ben Chu, is they didn't read the rules of court. They failed to follow the rules, and when you don't follow the rules, oh boy, you can say a lot of things about appeals, about crappy arguments and overloaded text and too much unnecessary research that serves nobody's purpose, that has nothing to do with legality, and you're just like throwing everything on the wall. That's one thing. But when you don't follow the rules, courts of appeals are, and Andrea Burkhardt, by the way, will tell you the exact same thing. Go ahead, ask her, an appellate lawyer. When you don't follow the rules, especially when you're an outside party, courts will throw your shit to the fucking curb, to the side of the road, because they will not hesitate. You have to follow the rules. And the easiest out, remember, I always say this, in appellate level litigation, judges will take the path of least resistance. If they can take your stuff and set it on fire Just because you violated one itsy bitsy tiny little rule, no matter how small it is, they will do that, especially if they don't want to read it. If they want to read it, they will bend over backwards to try and defend why it should not be excluded, and will find every nook and cranny to allow it to come in. That's why law is so fickle. That's why people they call me and they're like, well, what can we do, Larry? And I'm like, I don't know. I need more information. I need more stuff. I need more everything, Artfully Spun, welcome to the Mini Grills. Thank you for joining. So it's crazy. It's absolutely nuts. The violation constitutes sufficient grounds for denial by itself. We'll get to what it is in a moment. This is just the introduction, right? So that's number 3. Moreover, Ms. Hurt is very competently represented and does not need any assistance or additional briefing in support of her position. That's argument number 4. Nor should Mr. Depp be burdened with having to respond to such voluminous additional briefing. That's I think it's already blended in, but we can make it a number 5. Finally, the amici's arguments add nothing. They add nothing. God. The language is just so sexy. I swear to you guys, my nipples are hard. That's so. Hey Ben, what are you doing later? Finally, the amici's arguments add nothing to the legal analysis provided by appellant Heard's counsel, and appear focused instead on arguing with the jury's clear findings in favor of Mr. Depp on the underlying factual issues. The amici proceeds from the essential premise that Ms. Heard is a representative of domestic abuse victims, a premise that was emphatically and soundly rejected by the jury, who paid careful attention to the evidence presented during the 6-week trial. Both amicus briefs cherry-pick evidence that they believe should have swayed the jury to a different finding, but offer the court no insight on the legal issues actually at issue in Ms. Heard's appeal. Allowing this additional briefing would merely serve to complicate what is already a sprawling, misplaced fucking appeal. Bam! Accordingly, Mr. Depp most respectfully requests that the court deny Fletcher and Simpson motion. Thank you. Thank you. Come again. Oh my God. Oh my God. Whew. That's just the introduction. We haven't even gotten started yet. Vanessa Sparks says, super chat just for the nipples comment. I'm dying laughing. I am serious. Can you not see it on my face? Oh my God. It bears noting that the trial court rejected a motion to file an amicus brief at the pleading stage of this case for many of the same reasons that the motions. Oh, sorry. I need to make it bigger. I apologize. I got a little too excited here. It bears noting that the trial court rejected. So down in the district or the circuit court level, the trial court rejected a motion to file an amicus brief at the pleading stage of this case for many of the same reasons that the motions should be denied here, with the Chief Judge White noting on the record that, quote, Ms. Heard's counsel in this case are highly experienced and will present the law quite adequately to the court, end quote, while rejecting the suggestion that the trial court, quote, in ruling on a specific case should take amici's policy goals into effect, as opposed to really, in this case, on what the law already is in the Commonwealth and the evidence and facts that I hear. That was Judge Ascarati. Okay? All right. We had our little teaser, right? We had our a little appetizer. That calamari is just finger licking good. Give us the entree. Give me the steak, Ben. Give me the fucking steak with some A1 steak sauce, some bean sprouts, asparagus, and some mashed potatoes. Serve it on a platter, on a golden platter for me, Ben, please. Let's go. Argument number 1. The court should deny leave because the amici failed to comply with the applicable rules. The amici failed to comply with the applicable rules, to it, quote, a brief amicus curiae must comply with the rules applicable to the brief of the party supported. Let me read that again. This is Virginia Rule Supreme Court 5A23C. A brief filed by amicus curiae must comply with the rules applicable to the brief of the party supported. Simple, right? Because the amici are seeking to support Ms. Heard's opening brief on her appeal, they are required to comply with all the requirements set forth into 5A20, including the requirement under 5A20C, that the brief, and this is the magic language, the brief must contain a separate heading for assignments of error, with the list of the specific errors claimed to have been made by the trial court and, quote, this is from the rule, an exact reference to the pages of the record where the error has been preserved, with some ellipses. But this is taken straight from the book. Straight from the book. This is the rule that must be followed. A failure to assign error or insufficiencies in the assignments of error are both a basis for dismissal on appeal, to the as is the failure to adequately support an assignment of error with citations to the relevant pages of the record. Hello, we are on appeal here. You don't get to play mumbo jumbo. Let's fucking throw the, like, let's go fishing. Let's go see what we can catch some fish. Nope, no fish today. Like, Amber, you did this during the trial. You had every opportunity to do that, and reel it in. You caught no fish. You lost. You don't get a second chance to fish, okay? No more fishing for you. Now, they're not even fishing with a fucking hook. They're trying to fish with a net. Like, let's just throw a net in the water and see if we can catch any fish. You can't do that. That's not how appeals work. And Ben Chu understands this stuff, and he's literally alluding to the rules. They've been throwing everything in their amici briefs. If you remember when we read them together, if you have not read them along with me, please go check out the videos on my channel. They're there. Oh my God, they're there, and they are garbage. They're complete garbage. Not only that, and this is something, because I don't practice in Virginia courts, I didn't know this. I mean, it makes sense, right? They're supposed to cite to the record. They can't just like throw everything out there. They have to cite to the record. And Ben is pointing the finger and he's saying, you didn't do that. You failed to do that. Therefore, you violated the rules. Not only that, not only did you not cite to the record when you were drafting your amici briefs, you also did not include a page for assignments of error and which errors on appeal that are preserved that you are citing to. That is a huge, huge point. And failure to do that completely annihilates your ability to even have your brief examined by the court. You're just throwing the kitchen sink. This is, again, it's all tied in a nice, neat little package with a pink ribbon. I swear to God. Class A lawyer work right here. Here, in this case, this is argument number 1 still by Johnny Depp. Here, neither the brief offered by the Simpson amici nor the brief offered by the Fletcher amici complies with these express requirements. And by the way, one of them, I remember distinctly, didn't even ask for leave of court. They forgot to include that magical language. I believe it was the second one that we read. The first one, they're like, and we're asking for leave. And, I'm sorry, maybe they both asked for leave. The one thing that they forgot, I remember now, the second brief that we read forgot to mention that there's a special section where they have to say who agreed and disagreed with the amici filing. That's, again, one of the rules. It's a smaller one. It's not maybe as important. That's why it hasn't been mentioned yet, or it might be in the future. I don't know. I'm reading this pretty much coldly with you all. I just kind of glanced at the intro and I was like, this is it. This is it right here. I know lawyer work when I see it, you know? It doesn't take a genius. Like when you practice law and you know this stuff, you can smell it like a mile away. And I smelled it in this brief. That's why I got so excited. And when we started reading it, I mean, you saw these are all this is me cold reading the whole motion by Ben Chu, and it's glorious, like I said. So they failed to include whether or not Johnny and Amber agreed, their teams agreed with the filings. The first brief said it, the second brief did not. Here, neither the brief offered by the Simpson or the Amici comply with the express requirements. The Fletcher Amici brief does not contain a section for assignments of error at all, while the Simpson Amici included a separate section for assignments of error but failed to support it with any citations to the record. So one didn't even have a section at all. The other did have a section, but it was a bogus inclusion because they didn't cite to the record as required by the rules. Therefore, both briefs violated the fucking rules. Remember, we kind of mentioned that this was a very rushed work. There's your proof. There's your proof. In addition to their failure to provide any supporting citations, the Simpson Amici also violated the rules by using a size 12 font rather than the required size 14, meaning their brief is... Are you joking? Is this for real, actually? Oh. Using a size 12 font rather than the required 14, meaning their brief is actually even longer than it appears to be on its face? Again, this is a huge no-no. This is an absolute huge no-no. You cannot do that. You cannot do that. You can't violate the simplest of rules. When you're on appeal, reading the rules. I remember, what's that movie, Beer Fest? I remember my first appeal. I read the rules probably 100 times and then 100 more times before I filed my first brief. Why? Because I was petrified I'm going to get one tiny little thing wrong and they're going to throw that fucking thing into the dumpster and say, we're not reading it because you broke the rules. That's exactly what they do. This is what courts of appeals do. They don't give a shit about your client or your case. They care about you following the rules. And if you don't follow the rules, they're going to chuck your shit and they're going to set it on fire and you're going to be stuck with your thumb up your ass wondering, where did I go wrong? You didn't follow the rules. That's where you went wrong, you idiot. Man, that's how important it is. And if this is real, I didn't catch that. Honestly, reading it, I didn't catch that it was it's supposed to be a 14 font. To be completely honest, it's just I don't practice in Virginia. I believe Kentucky is a 12-point font. The couple of appeals that I filed are a 12-point font. Anyway, this is still argument number one. The court should deny, or is it? I'm sorry, it might be two. It's argument number two. I apologize. Argument number two. So number one, they broke the simplest of rules. They violated the rules. That is why it's first. It is enough by itself to get the whole Amici brief chucked, thrown into the fucking dumpster, set on fire, throw some gasoline in there for good measure. Number two, the court should deny leave to file the briefs because appellant is well represented and responding to the Amici would unnecessarily burden Mr. Depp. Subject to exceptions not pertinent here, a brief amicus curiae is permitted only on motion and by consent of this court. So for those of you who still had questions like, well, they're filed. Are they accepted or are they not accepted? Here's your answer. In Ben Chu's motion, it's permitted only on motion and it must have consent of the court. Consent. Consensual amici briefs. No non-consensual penetration of the record. Understood? It must be consensual. The court must say, yes, I permit you to bend me over and shove this shit in my throat. You can't just file and say, it's filed. We have it. No. It must be filed with permission. The rules, therefore, reflect that such briefing is generally considered unnecessary, nor would it be necessary or helpful in this case. It is undisputed. Normally, I dislike that language. Remember, when you're talking about facts that are kind of like wishy-washy, It is undisputed that, again, I'm going to be cautious here, but let's see what Ben, how is that language used here? Undisputed that what? Undisputed that Ms. Heard is well represented in this action by two major law firms. Okay, see, this is a good use of undisputed because literally nobody can ask any questions about it. All they have to do is look on the record and say, oh, she is represented. Yep, I see Ballard Spar. What's the other one? Van Vadere Black, Woods Rogers Van Vadere Black PLC. Yep, that's right there. Undisputed. But when you use like, it is undisputed that Johnny Depp is a husband beater or a wife beater or blah, blah, blah. Sorry, I've been on Twitter too much. The Amber Heard is a husband beater has been trending. So like I apologize. if Amber Depp is a wife beater, like Larry, are you here? Are you with us? No. Johnny Depp is a wife beater. It's undisputed. Shit like that, it just doesn't work. It just doesn't work because it is disputed. It is a question of fact for the jury. This one is totally undisputed. It is undisputed that Ms. Heard is well represented in this action by two major law firms, Ballard Spar and Woods Rogers, which also acted as Ms. Heard's co-lead trial counsel, On behalf of Ms. Heard, Woods Rogers and Ballard Spar have already filed an oversized brief of 55 pages that seek to put at issue 16 separate assignments of error. She certainly does not need 93 pages of additional supporting briefing from outside amici. As noted above, in light of the Simpson amici's use of smaller font size, the actual pages of extra briefing are closer to 100 to adequately present her arguments to the court. Oh, come on. Are you serious? This is what Ben is arguing. Moreover, Ms. Heard's counsel appeared to be acting in coordination. God. Oh, contain yourself, Larry. Contain yourself. He's like, oh, you want to shit on me? I'm going to make you smell it, motherfucker. God, look at this. Moreover, Ms. Heard's counsel, her own fucking lawyers, appear to be acting in coordination with counsel for the amici, which strongly indicates an attempt by appellant Heard to circumvent the page limits imposed on by both parties. For example, in the proposed amicus brief offered by the Simpson amici, which was filed and served on the same day as Ms. Heard's opening brief, Ms. Heard's entire statement of fact is simply incorporated by reference in an open acknowledgement that the amici had previously received Ms. Heard's brief and were acting in coordination with her counsel. That is crucial. That is absolutely crucial, because here's what Ben is saying. Okay. The brief and the amici brief was filed on the exact same day, because that's what the rules require. They have to be filed either before or the day of. You can't file it after. Then 100% the court will never look at it. The amici brief cites by incorporation and incorporates into itself one of them, the first one I believe that we read, incorporates Amber's statement of fact into, was it statement of fact? Sorry. Statement of fact. The entire statement of fact is incorporated by reference, which means they're in cahoots. They're working together. And how could they incorporate a statement of fact that was filed an hour apart? They didn't have time in the 60 minutes to read an entire statement of fact before they filed. And they have to file before. That means that they read it. And if they read it, that means they're working together. And if they're working together, that means she's trying to bend the rules to her bidding. And if she's trying to bend the rules to her bidding, we shouldn't let her do that, court. Lean on Me always says, oh, I can see it now. Amber Heard suing her lawyers for using the wrong size font. Hey, you never know. Ems Maurice says, my brothers, you on fire today. Love in every moment. Go do your thing, man. I don't know why I made that Jamaican. Please don't ask. Okay. This is what we're going to do, man. Is the next Curious George gonna be right in Jamaica, man? I don't know. We can do Japanese. We can do Chinese. We can do Indian. Would you like me to do? I can do a little bit of the Indian accent. They can do the French, the absolutely marvelous French accent. Don't forget to like this video, comment below, and subscribe to the channel, you stupid Americans. We can do all of those things. All right. Mr. Depp, who has received leave to file a brief of only 55 pages, would be unnecessarily and unfairly burdened if the Amici briefs were allowed. Mr. Depp must already respond to Ms. Hurd's highly unusual 16 separate assignments of error in a single brief. Further, Mr. Depp must also address the 3 additional assignments of error he identified for the court's consideration in the event of remand. If the Amici briefs were allowed, Mr. Depp would also be forced to address the 93 pages of argument, totaling 148, which we already understood to be closer to 155 given the wrong font, all in the same responsive brief. The burden on Mr. Depp for doing so would be substantial and unjustified. Number 3. This is argument number 3. Now, we already had like a few of them. They kind of lumped together, but this is number 3 in the motion by Johnny Depp. The court should deny leave because the arguments of the Amici are irrelevant and inappropriate. Such colorful language. Mr. Depp is not even going to fucking bother to address the substance of the Amici's arguments in detail in this opposition. Why? It is a waste of your time, judges, other than to point out that the arguments in their brief are for the most irrelevant to the legal issues on this appeal and consist largely of disagreements with the jury's factual findings, everything we talked about when we read them together. Disagreements with the jury's factual findings or complaints about the impact of the jury's factual findings on society in general. The slippery slope. This is the slippery slope argument. Kate Reverend Graham says, try a Scottish accent. I will be critical. I can't do it. I can't do a Scottish. I have to listen to Eve Barlow a little bit. No, thank you. Okay. So the slippery slope argument is completely worthless. We're not even going to address it here. The Amici cherry pick and misstate evidence that they maintain supports their personal factual conclusions to argue that the jury got the factual issues wrong. You want Russian? The Amici cherry pick and misstate evidence that they maintain supports their personal factual conclusions to argue that the jury got the factual issues wrong while ignoring the substantial evidence, including the testimony of credible disinterested witnesses that was presented to the trier of fact of Ms. Hurd's abusive conduct, admissions, and conspicuous lack of credibility. All right. Whew. Oh, sorry. While ignoring the substantial evidence, including testimony of credible, disinterested witnesses that was presented to the trier of fact, which is the jury, of Ms. Hurd's abusive conduct, admissions, and conspicuous lack of credibility. The Amici also expend many pages arguing that the jury's verdict is somehow harmful to abuse victims in general. Again, slippery slope policy arguments sometimes work. When you have absolutely nothing else, and this is your only shot at winning, and you have a ground to stand on. They have no ground, and they're using that argument. It is bound to fail. They're trying, they're failing, but they're trying. And Ben is like, again, you want to shit? Here you go. I'm going to make you smell it. That's it. That's how you lawyer. That's how you fucking lawyer. Right here. Such arguments are wholly inappropriate on appeal. What I've been saying since day one. What most of LawTube has been saying since day one, since we read this garbage. Now you have it right here in front of you. This court should not substitute its own judgment Because remember, judges like to defer to juries, literally what I've been saying since day one, much less the judgment of amici curiae for that of the jury. There it is. There it is. There it is. There it is. I'm going to read it again. Such arguments to the appeal to emotion garbage that we saw, remember? Such arguments are wholly inappropriate on appeal, and this court should not substitute its own judgment, much less the judgment of amici fucking curiae, for that of the jury. We do not substitute our judgment for that of the trier of fact. That's Kelly v. Commonwealth, a 2003 Virginia case. Welcome, Stacey D, as a new member. Don't forget to like this video, comment below, subscribe to the channel. Likewise, the amici's focus on some perceived social harm that will result to abuse victims generally from the verdict is both factually misguided, because the jury clearly and emphatically concluded Mr. Depp is not an abuser, and an inappropriate argument because the jury was tasked with making a factual determination with respect to only the parties to this action, not with sending a message to society at large. Because we're dealing with a real case with real people with real issues of defamation, 3 claims per side. We don't care about the outside world and its effect. We care about these 2 people, and now they're trying to bring in the entire fucking world and the 8 billion people that Amber said are allegedly on her side. I'd like to meet them. I know there's like 3 of them on Twitter. Where's the rest of them, right? That's what Ben Chu is saying, and he's citing to a case where closing argument asking a jury to send a message to society in general is improper. Improper. You cannot ask a jury to be like, listen, ladies and gentlemen of the jury, this case is beyond you. You need to send a message so that everybody knows not to do this stuff again. No, this is about these 2 people right here. Now, the effect, you can talk about the effect, but you can't say that you're sending a message, because of its tendency to inflame a juror's prejudices and to divert the juror's attention from the evidence produced at trial and focus it upon extraneous and inadmissible matters. In this context, it would be unfair to force Mr. Depp to use some of his limited pages in responding to these extraneous arguments. Moreover, a back and forth between Mr. Depp and the amici on these issues would be a distraction and had nothing useful to the court in assessing the actual legal issues before it on appeal. Conclusion: based on the aforesaid, the court should deny amici's motion for leave, dated December 5th. This was filed Monday, 2022. I wish I could kiss the screen right now. Respectfully submitted, Benjamin Chu, Andrew Crawford, Camille Vasquez, Samuel Moniz. See, they're pro hac vici. Ben Chu is licensed. He's got a Virginia State Bar license number. There it is. Brown Rudnick, Jessica Myers, Wayne Dennison, Rebecca Lecaraz, Stephanie Kalnan, counsel for appellee, and of course they are sending it to Rottenborn, Treese, McCafferty, Stemland, all at Woods Rogers, and to Axelrod and Brown from from Ballard Spar. And they also, by the way, they also sent it to the other lawyers over at Simpson Thatcher and the other firm, the IP business law guy. Like, they sent it to literally every lawyer on the Fletcher amici, the Simpson amici. They send it to everybody because everybody is on notice. Oh, man. What an absolute glorious piece of legal writing, you guys. An absolute bombshell. I started to say this in the beginning. I'm going to say it again after reading it. This was a cold read. Like I said, I skimmed it and I already felt like, oh, this was going to be a godsend. This is how you do lawyer work. See, when you don't have a good argument, you try to cherry pick. You look and you find and you're like, well, let's see, what do I have? What what do I have? Let me find and let me throw this and let me throw that. And let me throw this and let me throw that. And then before you know it, you have a fucking stew that you're like slow simmering on a low fire, and you're just like mixing it together. And okay, I gotta add the pepper, and then I gotta add the salami, and then I gotta add this, and I gotta. This is Amber and her team. That's what they're doing. They're stewing a fucking stew pot, or they're boiling a stew pot. Meanwhile, Benchu is making an omelet. He's just like, all right, I just need a little pepper, a couple of eggs, a little bit of cheese, a little ham, whatever you like in your omelet, and it's done. It's ready. That's the difference between good lawyer work and shitty lawyer work. Shitty lawyer work is is a stew of like slow simmering garbage that takes a long time to read, a long time to understand, has a lot of, I have to refer to this, I have to refer to that. I need to make sure I know this fact. Is this fact accurate? I don't know if this, undisputed. Is it undisputed? It seems like it would be disputed. That's a little disputed. I don't know. I'm not sure. If you have that when you're reading a brief, that's how you know you have a bad argument and bad lawyering. When you read Ben's motion, it's like, look, you guys, bam, 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 bam. Thank you. Sign off. Submit. That's the difference. That is the difference in the quality of lawyer work and the quality of argumentation. And don't forget the most important thing, the quality of the case. The quality of the case. Johnny has the better case. He's already won on the, remember, what do I call appellate court? Appellate court is loser court. Every lawyer will tell you, I don't want to be in loser court. Why? Because I want to win on the trial level. If I'm appealing my case, that means I lost. I don't want to go to loser court. I want to be in winner court, the district court, or the circuit court if it's a felony case, or in Kentucky, a case over $5,000. So Benchu has definitely dropped the mic here, Jennifer Coots. Thunder Rain says, I still can't believe they changed the font size. I can't either. And I said that if that's a fact, I mean, they wouldn't have stated it but for it not being a fact. I guess I didn't pay enough attention to the brief itself, because I'll have to go back. I'll have to go back and look at the two Amici briefs and to see if they're actually different font sizes, because that's a bombshell just by itself. If you're breaking the rules to get more space, you will be discarded. At best, courts will be like, well, we're going to count to about how many pages it would be. Like, this is 50 and we're not reading anything else. So we're just going to throw into the trash 7 pages. So we don't even get to your conclusion at that point. Thank you for the super sticker, Sam Panther. Welcome to the channel, Bessie Knox. Ben, definitely chewed that up, Ems Maurice. No question. Matrix says, can they attach the Amber Heard third left on the sidewalk in Spain after visiting a bar? Maybe they could compare the turds. That's forensic evidence. Oh boy. Okay. I'm not going down that path. I'm not going down that path. I already had enough with the whole arguing about whether her baby is real or not. I'm not going down that path again. But whew. All right. I hope you all had some fun. I hope you all enjoyed this. We had a DUI guy twice today. We had the Jason Goodman show, and now we had this show. So I hope you all enjoyed yourselves. I hope you all learned something. I hope you all had fun. I sure as fuck did. I'll tell you that much. When I read a good piece of writing, when I read a good piece of lawyer work, it just gets me going, you guys. I'm telling you, it makes my nipples hard. It makes me excited. It makes me happy. It makes it fun because I get to read it emphatically with fervor and panache and force, like it is meant to be read. You know, Harper's one-nighter says, tip the host. Thank you. Don't forget to like this. The best tip you can give me, by the way, is a subscribe. It's free. It's the beautiful thing about a subscribe is that it's fucking free. It's just a +1 on my subscriber base. It's totally free. If you're so inclined to also comment below, also free. And like this video, oh my God, that's free too. You know, if you want to buy some merch, go for it. If you want to join on as a member, go for it. But I love every single one of you. I really do. Thank you all for joining me. There's like 2,100 people here at its peak. Maui Babe says Ben is going to squash Scamber, and I am here for it. He certainly did. He certainly did. Don't forget to like this video, comment below, subscribe to the channel, join as a member, go buy some merch. I am gonna go sleep because I need rest. So I will see you all tomorrow. Don't forget, Nick Rekieta is joining us tomorrow. We're going to talk about Bot Sentinel and Boozy's new project, Spoutable, and how it is probably subject to so many fucking violations of the law. Then we're going to read Curious George, and then we're going to have a body language expert, Jesus, on Monday. So I will see you all next time. Bye, everybody.